Good morning, everyone. Special morning recess edition of Live with Tim Panic Law. Um, this is very, this seems very different than the first trial. So you have to think, remember, Dr. Welcher didn't testify in the first trial. So you think, is ARCA making their findings based around whatever the witness says? Like, this is why they're not true. Not, here's what our findings were in the first trial, and they haven't changed. We were right the first time. That's a very, very risky proposition if you are the defense, to have the witness say something different in the first trial than they're going to say in this trial, because you are just opening the door for cross-examination. And it's like, okay, I thought the truth was what you said in the first case. Why is it changed? Oh, because the Commonwealth introduced an expert witness who simply interpreted the black box data and the digital forensics, and now you have to say they're wrong this time. So if you're Hank Brennan, the whole point of this cross examination will be they're just going to say whatever we put forward was wrong. They're not going to explain it why, because they're like, here's what the taillight is at 10 miles an hour. It's like, he wasn't hit. The officer O'Keefe wasn't. That's not the Commonwealth's theory that he was struck at 10 miles an hour. Um, he was struck at like 24 miles an hour after going in reverse for 53 feet. That's what they're alleging. The whole potato cannon thing is just strange. I thought they would strike that in this case, but maybe you talk about how it could have potentially, yeah, exactly. The tail light's already cracking at 10 miles an hour. And it's like, now add 2.5 times that kind of miles per hour, what it's going to do. It's going to shatter. And it's going to be so fast, it's going to embed the piece of the taillight in the clothing. And it's just, like ARCA knows what's coming. Because in the first trial, remember, ADA Lowley asked, did you know that there were pieces of the taillight embedded in the clothing? No. Did you know his DNA was found on the bumper? No. Did you know that his hair was found on the taillight? No. So they were only given enough information to say whatever kind of opinion matched the information that they had. So I think the trial strategy has changed. Now they're just saying whatever Dr. Welcher is said is wrong, and this is we're not trying to do that. Thank you. I love the three-piece suit. It's when I got this custom suit, I was like, I need it to be a three-piece because I want to bring it back into style. I'm kind of jealous of the people from the Gilded Age being able to wear this around. I'm trying like hell to get my wife to get me a pocket watch to match because I don't want to look like a train conductor from the Polar Express, but I think a pocket watch would look absolutely fly. Questions. I'm assuming Hank will get cross today. If Alan Jackson is smart, he'll make the cross in the afternoon, like basically filibuster. My blue suit is way nicer. All right, all right. I've never heard of that, but good to know. If I'm Alan Jackson, I make sure this direct examination takes it to around 2:30 in the afternoon. The reason is this: Friday afternoons are very, very tricky for juries because remember, this is the Commonwealth of Massachusetts, and it's now summertime. School isn't out, but baseball games are happening. People go to the Cape on the weekends. And so when afternoon occurs, the jury's not always going to be paying attention. So if Alan Jackson is smart and he's done a lot of trials, I would think he'd make sure that his direct examination continues till roughly 2:30 p.m. because he's not going to want the jury to come back fresh after lunch and listening to what Hank Brennan says. He wants to bore them with more testimony from whenever they go to lunch till middle of the afternoon. Then they start cross examination. And the reason you do that is so cross examination occurs when, like I said, the jury's not paying attention. They're already thinking about the weekend. That's why I have to think partially the reason you have probably your most important witness testify on Friday morning with the hope that cross examination would occur by Friday afternoon. Or it could take the entirety of the day with the hope that the jury goes into the weekend thinking about what ARCA just told them. So they have an entire 2 days to reflect on what was just said. either way, it's kind of it's likely going to be one of those two things. I would think. What did I think of um, the reconstruction? It's like you're looking at the taillight, and he's like doing this. It's like on the arm. I'm like, are you guys like are you guys like almost like conceding that the taillight hit the arm? Because that's what it looks like. So you testing out and then like look at our findings. Like, you can see it's cracked. It's only 10 miles an hour. Are you doing it at 24 miles an hour and see what happens to the taillight? The potato cannon is still just so bleeping weird. It really was. And it's like, what are you trying to say? That Officer O'Keefe chucked this glass at the taillight and shattered it? Is that what you're really saying? It's like he threw it at 37 miles an hour. The guy's got a cannon. No, like, come on. It's the middle of winter. Nobody can throw the glass and be able to drill it perfectly. Or did he hit it like an inch away? I just, I, I don't know. Um, I really don't know where Alan Jackson is going with this. This whole direct examination seems like you can see he's, and I said this on Court TV, what I was just being on. He's being uncharacteristically timid. That's not Alan Jackson's style. He's very confident in direct examination, and he can be very aggressive. He doesn't need to be aggressive, but he seems very, very timid with this direct examination, which tells me I think he's very afraid of opening a door um, that Hank Brennan wouldn't be able to go down. I have to think it's got to be the federal investigation because I think he said the entity is what he calls it. This isn't Mission Impossible. We know the entity is the federal government, and we have nice individual. Wolf is destroying. Is maybe paid. I'm sorry. That's pretty good. Uh, yeah, that's not really remotely accurate what that individual just said in the chat. When I'm watching this case, I'm looking at it from both prosecution and defense standpoint. I actually thought ARCA did pretty relatively well in the first trial. Like their findings made sense, and that's before they knew about the coordination, uh, talking in violation of sequestration order on the Signal app. I thought they actually did really good in the first trial, and they made a compelling case. Like, huh, maybe there is. But unfortunately, at the end of the day, um, yeah, I'm not even going to respond to that. What I can tell you is what I'm seeing from ARCA is I think they have more information now. They have to make their opinion work with the actual facts that they were presented that they didn't have in the first trial. They didn't know about the embedded piece of the taillight. They didn't know about the hair on the taillight. They didn't know about the DNA on the bumper. The DNA could be touch DNA. The hair, that's going to be tougher. I've seen people try to argue that the hair belonged to the nephew. Nobody's going to believe that. Nobody's going to believe that that hair was anybody but Officer O'Keefe's, especially when it's a DNA match. So I think that in this case, ARCA is just trying to say Dr. Walsh was wrong. We're not really giving our opinion about what actually happened. We're just saying his says some really holes, and that's their prerogative. Remember, the defense doesn't have to prove anything. So I think that's more of a safe approach, but it's also opening yourself up to, all right, do you actually have an opinion? No, not really. And some of the things we know that he didn't actually know that I think Dr. Welcher talked about how the vehicle was went in reverse. The digital forensic data backs up that theory, the black box. So did ARCA know about that? I don't know. And that's going to be an interesting situation because he says, I wasn't aware of any kind of how fast the individual was going. We know that's not true. ARCA might not be aware of it, but that's likely to come out in cross examination. Is trying to disprove also why that's a hair from the head. Yeah, I think it's more of a conservative approach this time. In the first trial, it felt like they were just going for the W. They're going for it all with their testimony. This time, it's kind of like a layback and like, let's just say why these findings are incomplete, and that's perfectly fine. But it's not really convincing. And Alan Jackson's direct examination is not really one that's I'm finding as compelling as what he usually does with some of his witnesses. Like I said, he's being uncharacteristically timid. Um, yeah, and people talking about the conspiracy theory, I don't know if you're going to be able to really go into that further unless they call Mike Trooper Michael Proctor, former Trooper Michael Proctor, Brian Higgins, Brown Albert. I don't even know if you can get the third party culprit instruction because there's just no evidence of that, and they haven't even introduced, and the people haven't been evasive, and you can't really go like use Kelly Dever um, as a predicate to be able to doing that. Um, that so somebody says Alan Jackson doesn't seem like the same lawyer was in the first trial. That's actually I've kind of felt that even in the pre-trial because in the first trial he was so confident, his crosses were great, his presence. This trial he's kind of like hanging in the back, taking a back seat to the case. I respect him for coming back because he could have easily just taken the hung jury in the first trial as a win and played it off, but instead he came back to do it. So I am like I do respect that, but I do say that he hasn't been himself. I don't know what it is. Maybe it's just the trial strategy, and that's what they decided. But it seems that he's more of kind of like a supporting individual as opposed to being the lead counsel on the case. I think that in this trial they really don't have a lead counsel. I think Attorney Alassi and himself are kind of just going switching on and off. I would expect Alan Jackson to do the closing just because he's much more compelling. He has a much greater presence than Attorney Alassi, and has a lot more experience thinking on his feet in front of a jury. Um, yes. Could it be the sanctions? I don't know what they're going to. I can't. I have to think the judge is going to impose some. I don't know exactly what they will be. Monetary fine. Um, but I don't think that's going to come until after this case is over. And he can't be that afraid of sanctions that are already done um, because you're not going to do anything different. I just think he's doesn't want to open up um, as many avenues as he can during cross examination. Defense attorneys don't usually do direct examinations. They're used to crossing. They're used to asking leading questions. That's what you're seeing a ton of. He's asking a lot of leading questions, and usually you object. But Hank Brennan is like, if I just keep objecting, it's just going to keep getting sustained. The jury's going to start to get upset with me, and that's not what he wants. It's like he's not really you only object to a leading question when it's something that's like, all right, this is really egregious. I have to object. Otherwise, he'd be objecting every single question. Um, there is, as we remember from the when Arca was allowed to testify, even though with the late discovery and everything, the judge said the only, I think uh, the only way to make this whole or was for a robust cross examination. So I think what some people are saying is that they're going to give, Judge Cannone is going to give ADA Bredum a seriously wide latitude to be able to cross examine Arca. And I don't know if by the end there's going to be anything left because this is the witness he's been waiting for since he took this case because he knows if this person's discredited, they don't have a defense. There's no um, there's no conspiracy. There's because if there's no conspiracy, then you can't really argue there wasn't a pedestrian strike because otherwise the two go hand in hand. Because how do the pieces of the taillight get embedded in the clothing? If it's not a conspiracy, then what is it? You can't really explain it. That's the only way to explain the no pedestrian strike is if they're planted. So I think I got some questions. Do you think it's pretty bold for Allen to do the questioning instead of Balassi? I think it's more of a familiarity with the witness because Alan Jackson probably just copied and pasted 70 to 80% of his questions from the first case. And and Attorney Alassi isn't as familiar with ARCA. The other witnesses, the new like expert witnesses, that seemed to be his forte, but he didn't. ARCA was retained originally by Alan Jackson in the first trial, so I think it's more of a familiarity. And yeah, Attorney Alassi is definitely struggled with cross examination. This is not really his forte. He's certainly knowledgeable, but trial practice is an art, and it's going to take him some time to get there. Now that the Commonwealth's case in chief has been presented, will Brennan be able to introduce the remaining clips, Karen clips? I think that you're going to see more Karen clips in rebuttal because remember, closing arguments are limited to what has been presented in evidence. The parties can argue what they say is in evidence, but you can't really argue things that aren't in evidence. So if there's going to be more clips that are going to be used during closing, they're going to come in the rebuttal case. How little but a little. Okay, Matt, can you explain a little about how a rebuttal case would work? Okay, so in a criminal prosecution, you have the prosecution's case, then you have the defense's case. The Commonwealth has the ability to put on what's called a rebuttal case. That is to rebut the defense's case. So if the defense didn't put on a case, there wouldn't be no rebuttal. So what I expect to happen is this case is going to be based around the dog bite testimony from Dr. Russell, rebutted by Dr. James Crosby, and the accident reconstruction critiques, if it were, by Dr. Wolf, will be done by Dr. Welcher. So they're going to be like, this is why they said we're wrong. And it's like, no. This is their argument is flawed for this reason. I know most of you might be surprised, but Dr. Crosby is going to be a very compelling witness. I know him from other cases. So that's going to be something to watch. Have you seen lawyers play dirty like this before? There's a very fine line between playing dirty and zealously representing your client. It's approaching dirty. Like Kelly Devers, that was pretty much the furthest I'd seen the line crossed by Alan Jackson, especially hearing that the allegation is that he threatened her with perjury charges. A lawyer can't do that. That's a real ethical concern. So I think that was where the scariest crossing the line is. But they've, for the most part, in my opinion, towed the line between zealously representing and kind of shady defense tactics. How do you think that this witness will impact the jury? It needs to improve. It needs to be more clear. It needs to explain why. Because right now you see the 10-mile-an-hour impact and the taillights cracked. It's like, all right, are you going to go further? Are you going to go higher up, faster speed? And they need to be able to show that the taillight wouldn't have cracked in those same situations. I definitely think not seeing the actual vehicle in question, not going to the crime scene, is almost like willful blindness, like selective blindness, choosing what to know and what not to know so that your findings do not actually go into conflict. Because you can't really, if you don't know about something, you can make an opinion about that and be like, well, I didn't know about that fact. Do you think, the cross will come Monday and not today? It's possible, depending on how late it goes. Judge Cannone might be like, all right, it's 3:00. We're just going to allow you to go for the weekend and start Monday instead of starting a cross-examination. That would be really helpful to Hank Brennan because his cross-examination, he wants the jury paying attention, and 3:30, nobody on the jury is paying attention on a Friday. Does the defense get to put on a rebuttal case in Mass? Not that I'm aware of. We're not, because I've seen with this case, they have the direct cross, redirect, recross, redirect, recross, and like, it just needs to end sometime. Signal app getting lots of free advertising. Yes. Between this and what goes on in Washington, Signal is getting a lot of free advertising. So it's warm there today, so the AC has to call an early day. It just because here in Florida, we have the heat year round. So all courthouses have central air. Massachusetts, you only need central air out of a couple months out of the year, probably July, August, and September, realistically. So when she does that, it's like when a jury is getting way too hot and the air conditioning isn't working and the fans, that's a really uncomfortable environment to doing it. It's like, yeah. And with them being what they consider ahead on the case, it's a situation where they'd probably just let everybody go. So yeah, and it's endless. If you just keep doing like, and our witness is going to rebut the rebuttal witness, and it's like, come on, just sit down at some point. You have to rest your case at some point, and you better do it on a position of strength. And the question I've gotten a lot because now everything was going on with this case and me appearing on 48 Hours. Live now from Fox, and pretty much anywhere I go, somebody stops me to ask me about this case or ask me about another case. And the big question I always get asked, will the defendant take the stand? And I answered this yesterday on Instagram, but I wanted to talk about a little more in depth in this one. The defendant has an absolute right not to be a witness against herself. In this type of situation, that's usually understanding that the witness has never actually said anything. And we've seen all the countless clips. So she is kind of being a witness against herself, obviously. But is she going to get in the witness stand? I hope not for her sake, because what Hank Brennan's about to do to Arca, it'll be 100 times worse for the defendant because he will keep her up there for 3 days and flesh out every single inconsistency, every single lie, and then probably go into the witness intimidation aspect as well. It's like you don't even need to call Aiden Kearney about that. You can just call the defendant, and then when she tries to deny it and all this stuff, then another witness is called in a rebuttal, and it's endless. Um, and I don't think, and this is what I said. If she takes the stand, I think that's the only way where they actually get a murder to conviction. There's enough evidence to sustain it, but I just thinking to the jury to be able to get to that murder to charge, they have to think that, all right, she did it on purpose. She intended to hit him. She might not have intended to kill him, but she intended to hit him. And if she intended to hit him, that means she had to go home and then make all those phone calls to cover her tracks. And then she had to back up the vehicle, her vehicle, into Officer O'Keefe's to make it look like she cracked the taillight. And all of those things, that's speculation. That's where you have to go to be able to get to that murder two conviction. You otherwise it could be she was really drunk, she was backing up, she didn't know he was there. They'll make any benefit. So if I were to say most likely, outside of the defendant taking the stand and flopping like Ashley Benefield in the Black Swan murder trial, I don't know. I think the jury hangs on murder two and just likely fines for lesser included. What could she possibly say that would make it better? Nothing. There's nothing outside of her taking the stand that says, I saw John O'Keefe enter the residence. Because remember, Alan Jackson said there was somebody who said they saw Officer O'Keefe enter the residence. Is that the defendant herself? Would you call her solely for that reason? That's an awful risk. And I think she intended to hit him and made those calls thinking she just clipped him and didn't hit him, kill him. That's possible. I'm still trying to. What about the third charge? Is that likely to stick? What we know from the first case is that allegedly the jury was hung on the murder charge and the leaving the scene. So if she wasn't aware that she did it, you need to do so with knowledge. So if she didn't know she hit, then an argument could be said like, well, it wasn't knowing. She might have done it, but she might have not knew she did it. So, but I think this time it's a lot stronger because we actually have the vehicle, where the vehicle was, and where the phone was. So we know where the exact impact location is, the alleged impact location, and it makes it a lot stronger. And I don't know, like I still need to look up the clip. I need more context on the mortally wounded comment because he didn't look mortally wounded. I want to say she said that when they got back there at 5 a.m, but I need to look up the context of that. Yeah, but it is the intent element is there. You put it in reverse and with 35 RPM. I was just driving my car yesterday, and I was on a straightaway, and I passed a car, and I got it up to 35 RPM, 3,500 RPMs. My car was flying. So I can't even imagine what you have to do that fast. And people are like, oh, well, she might have been stuck in the snow. That's why I came up. It's like, come on, stop. You're not going to go back. Nobody who's from the Commonwealth of Massachusetts and was like nobody would back up in a reverse 24 miles an hour, 53 feet in the snow. That's just dangerous. So what does it say? The interviewer asked her if she was the moment. It was the moment she dropped him off, and she said yes. She said it right after she dropped him off. The interviewer asked her. So it is going to be a situation where the defendant, they need to explain. I don't know where they're going. I don't know if there actually is a defense. With the digital forensic data in the black box, the defense is kind of put in a bind. And they're almost hoping that it's like maybe Arca could convince them to not believe the findings. And that might be enough for reasonable doubt because I've long said the conspiracy angle was never the best avenue of attack. It's just so far fetched, so ridiculous. It involves way too many people who don't know each other. Somebody let me know when they go back in session because obviously I don't want to take away time from that. So I'm going to do a few more minutes on this with any other questions. Um, wouldn't make sense when she found if she had blood and black eye. And one of the things I remember that was great testimony that Hank Brennan's going to need to remind the jury, he had glass in his mouth. Like she pulled glass out of his mouth. How did the glass get there? Did he put it up to so that's going to be interesting. Was he beat inside 34 Fairview while he was drinking something and that's how no, come on. Like stop. Would you take her case as a defense attorney? What would your strategy be? A plea deal? It depends. So every attorney has the right. Every individual charged with a crime has the right to a defense. I've represented people charged with murder, people charged with rape, everything, and it taking her case wouldn't be anything. I would take any defendant's case and listen to it. I can choose to take it or not to take it. But it would be a trial strategy. It would have been in the investigation, flawed investigation, and just hammer that all day. And I would have figured out and find an expert to be able to explain the pieces of the tail light in the clothing. But I don't know if you can. And I think that's what ultimately prevented the acquittal in the first trial because it was there. The acquittal was pulled out of his nose. Apologies. The acquittal was there for the taking, but if they couldn't get in the first case when it was poorly presented, the facts were like confusing at best. I have to think this jury is not going to then be like, well, yeah, we all agree, and cover up, not guilty. Yeah, just the picture of the microscopic piece of the taillight embedded in the clothing, it's just so damning because it's like it's so clear it's a piece of the taillight and it's the size of smaller than a piece of rice. That was the largest piece was a piece of rice, and it's just oof. And I have to think Hank Brennan's going to cross them arc on that because if they can't explain that, they're going to be like, I have no opinion of that, which is essentially they're just going to be waving the white flag. And she said it gushed blood or they're lying. Yes, absolutely. Lowley, by calling, I knew that was kind of the case when he called Proctor and had him re up the text messages. Like, get out in front of it. That's good strategy, but it didn't stop Alan Jackson from destroying him on cross. So I don't know. Like, it was, yeah, I think especially at EDA Lally was too busy trying to to dispel the defense's case that he kind of forgot to prove his own case, and he kind of got bailed out because that very well could have ended in an acquittal. It shouldn't have, but it very well could have. I think that's where we're going to leave this for now. To get back to court, thank you for joining me and follow me throughout the day on Twitter. I'm going to be in and out of court throughout the day, and I'll do independent updates. Oh, do you think Jackson will go all day with Arca? Yes, I think that'd be the smart play. And I think with that, have a all wonderful weekend, everyone. I'll see you on Monday.